What's up, everyone? Welcome back to the channel. Let's talk about it. And in this video, I'm going to be sharing all of my materials that I had submitted to the Court of Appeal, appealing that outrageous family court restraining order and those court costs of $60,000 that were straight up fraudulent. I'm doing these videos because I feel like I've taken so much abuse before a handful of judges, including the ones in the Kitchener-Waterloo courthouse. You know, you guys have seen the previous videos, this whole family court thing I got unlawfully dragged through. Justice Martha Ann Tweedy, you know, causing all those adjournments. And then, to be honest, you know, trying to be slick and filling out the applicant's trial schedule endorsement form, which she should have never done, which should be considered a major misconduct that no one wants to address, including this broken and biased Canadian Judicial Council, these screening officers who are protecting this judge. So I filed an appeal with the Court of Appeal, and I'm doing this video to share my materials, just to show you guys what they are ignoring. And it's frustrating to say the least. This judge that we went before, Justice Favreau, she made a bunch of outrageous statements on this endorsement of hers. She just straight up piggybacked off of Justice Gibson's endorsement, which is riddled with error of law, error of facts. You know, that judge said that I lived with my ex. I moved back in, I emailed her, I called her, I breached my temporary restraining order, I was not a tenant. You know, none of these things happened. You know, my ex emailed herself. You know, this all started with a fraudulent home insurance claim where she got paid $9,000 for damages that never occurred. You know that the Waterloo Region Police refused to investigate. The Kitchener-Waterloo Prosecutor's Office refuses to investigate, stayed charges. Several judges in this Kitchener-Waterloo courthouse refuse to investigate. You know, it's just insane. Like I feel so frustrated, but at the same time, I can't believe I'm going through this. And, you know, this all falls down to this whole family court thing, where I was unlawfully dragged through, and nobody wants to question, because we've got Canada's only Superior Court judge who got his training, his judicial training, from the Canadian Armed Forces. And when every one of these judges looks at his endorsement, they want no part of questioning my materials and questioning these errors. So this video, I want to share with everyone my materials that I had submitted to the Court of Appeal and the ongoing abuse that I'm taking from judges, because I feel like I'm a self-representing litigant. They can get away with this. You know, in this video, I'm going to be sharing with you guys, you know, if you're thinking of doing an appeal as a self-representing litigant, right off the hop, if you can avoid it, I would avoid it. But you know, if you can't afford a lawyer and you want to file an appeal, I'm going to give you some kind of pointers here on what you need to submit. So, in this video, I'm going to be sharing 3 videos. One, you go to the Court of Appeal website and they tell you the materials that is required for filing an appeal. That's a motion record, a factum, transcripts, if any, book authorities, if any. Justice Favreau ran down my materials, and I'm going to get into statements that she made, and part of it was that I never filed an affidavit. Well, as a self-represented litigant, I was instructed from the administrators at the Court of Appeal to go to the website and follow the instructions, which I did. The website, like I said, nor does it say that an affidavit is required. My materials that I did submit, that were, you know, if you guys can, you know what, I would love to, if you guys can put in the comments, if you guys know anyone or if you yourself have personally gone through the Court of Appeal, I would love to know how you wrote and submitted your materials. Because the materials I submitted, it is evident, you know, I had no business ever being in family court. It is evident that trial judge, who I believe was handpicked, you know, I had less than 24 hours notice for this trial. Trial schedule endorsement form never filed, required by law. The main restraining order application was never signed, required by law. A trial record must be served to the other party 20 days before the trial. It was served by 8. It's required by law. You know, this is potentially Canada's most corrupted family court case in Canadian history. And all these courts and judges collectively are keeping me down so the truth doesn't get out. So, sorry, to stay on topic, okay, my materials were my motion record of appeal request, my factum, my Schedule B, my 16B affidavit of service, and a signed and dated letter to confirm I served the lawyer with the Court of Appeal. This judge that was handling the case, it was a disaster. It was, judges are supposed to be fair and impartial and make decisions based off of evidence and facts. And to be honest, this judge just piggybacked off an endorsement that was riddled with errors of law, errors of facts, and there was intentional contradictive statements that cannot be backed up by any of the evidence or the facts. So some of the things that this judge said that I kind of thought was a little bit outrageous was, and you guys can see this stuff in my other videos, is that she says here, there also appears to be no merit to the proposed appeal from the cost order. To appeal the cost, Mr. Dobson would have to meet the high test to obtain leave to court. Mr. Dobson would have to show that the trial judge made an error in principle or that cost decision is plainly wrong. During argument before me, Mr. Dobson suggested that the bill of costs submitted by counsel for Ms. Wibbs was fraudulent without any evidentiary foundation for this allegation. In any event, the trial judge significantly reduced the cost sought by Ms. Wibbs. It is hard to see how Mr. Dobson could meet the high bar for obtaining leave, or if leave was granted, how he could succeed on appeal. That is just straight up crap. This friggin' lawyer, John David Ekping-Young, submitted a fraudulent bill of $160,000 of hours never worked and money exchanged hands. Do you guys know when you bring to a judge's attention about this potential fraudulent bills that they are obligated to show the other party, to make the other party show proof of payment? You know how many judges would not do that? Because, why wouldn't they do it? The judge, and you'll see in my materials, this lawyer admitted his client only paid $7,000. And then they foolishly and ignorantly asked for $160,000. And this judge is going to sit here and say, oh, Mr. Dobson showed no proof. How hard is it for these judges to simply say, hey, Mr. Ekping-Young, Mr. Dobson is calling you out on these costs. They do seem a bit high. You must show proof of payment. All these judges wouldn't do it. And then we got this statement here she made. Finally, while Ms. Wibbs did not provide evidence of prejudice, if this appeal is allowed to proceed, it is evident that the trial judge's reasons, and even from the materials provided from Mr. Dobson himself, that Mr. Dobson has engaged in a pattern of harassment vis-a-vis Ms. Wibbs. The proceedings have included ongoing attacks on Ms. Wibbs and her counsel, and the trial judge described as scorched earth litigation tactics. These are hallmarks of vexatious proceedings. To allow Mr. Dobson to proceed with this appeal would simply allow him to prolong this conduct, which is obviously prejudice to Ms. Wibbs. It's like this all started with a fraudulent home insurance bill. And then it started with a fraudulent bill of costs submitted to this trial judge, Justice Gibson. Okay? I had tried to get out of these proceedings. They would not let me unless I gave into extortion. This is straight up crap when I'm reading this. This frustrates me, and this is not true. And this is why I'm doing this video, because I'm going to show this judge just ran down my materials, okay? This judge accepted this lawyer's materials 10 minutes before the hearing, unsigned, uncommissioned. And you guys aren't going to tell me that's a little bit shady, okay? How is the lawyer in good standing getting away with this stuff? Why are these judges allowing this? Because it all comes back to this family court proceeding. Again, I was unlawfully dragged through. I had no business ever being into it. And I'm going to keep going public and sharing the honest truth. You know, the RCMP needs to get involved. They need to investigate these judges, okay? The Chief Justice of Canada needs to know about what these judges did to me, okay? Because this is straight up crap. A year ago, I had everything going for me. Working out Windsor, licensed electrician. I get this lawyer, submits this fraudulent bill, starts a garnishment application. 72 days after that, they get awarded that fraudulent money. My bank accounts have been frozen for almost a fucking year. And then people are going to be surprised I'm doing these videos. And these courts are not being handled fairly. These judges are not making decisions based off of evidence and facts, and they're not handling these proceedings impartially. When you got a judge making statements like this, they're just outrageous. You know what I mean? So I'm tired of taking this abuse, the abuse I've taken, and I want to focus on this video on sharing my materials that pretty much fell on deaf ears and was completely ignored. So you guys can see for yourselves, this judge ran down my materials. You can see one of the very first materials was that police report that my ex wrote to the Waterloo police when I lived with her for that short period of time, renting her basement, admitting I was a tenant, paying rent. She applied to the landlord-tenant board. And you got these judges collectively protecting her, and this lawyer who was actually in the middle of being fully prosecuted by the Law Society Tribunal to have his license revoked because he's ripped off a client for $46,000 and he's done something very shady to Legal Aid Ontario. He's probably submitted more fraudulent bills to them and he's been caught. And all these judges are doing is supporting this lawyer who should never have been practicing in the first place. So, you know, I appreciate everyone that's supporting my channel. I'm tired of staying silent with all this courtroom corruption that I'm dealing with. And I think it's all tied into this major police brutality case that no one wants to talk to, that they've just railroaded me into space. These are my materials I want to share with everyone. And if you guys are thinking about filing an appeal with the Court of Appeal of Ontario as a self-represent litigant, I'm hoping this video will help you navigate through this simple but yet complex appeal system. But if you guys can, avoid it at all costs. You know, so I'm going to leave the video right there. Thank you guys for watching. If you haven't already, please subscribe to the channel. Comment if you've been before the Court of Appeal, self-represent litigant. I want to know your guys' experience. And, you know, thank you guys for watching. This is another video. Let's talk about it. And these are my Court of Appeal materials before the Court of Appeal of Ontario.